under section 376, my lord. Allegation of the prosecution is that when the prosecutrix eloped with me, she was minor. Now, my lords, the prosecutrix eloped and stayed with me for a period of 1 year and 3 months. She comes back, she was detained, and after that I was sent into custody. Her statements are recorded before the trial court. In her statements, she said that at the time concerned, I was a major. In fact, now they have consummated the marriage also, that is which has taken place. There is a child, and they are both living. Unfortunately, I am in jail right now.
You are in jail?
Unfortunately, I am in jail, but prior to that, we were both living.
जेल में रहते हुए कर लिया?
नहीं, शादी सर 1.5 साल हम लोग साथ में रहते. At that time, we got married. Now we say that the prosecutrix is major. The prosecutrix accepts that. The parents of the prosecutrix also say that she was major at that time. At that point in time, my lords was of the opinion that we should wait for the evidence of the headmaster and the investigating officer, and I was granted such a liberty. Now even they have been examined, my lords.
क्या कहा headmaster साहब?
Headmaster साहब ये कहते हैं कि the document which the prosecution relies upon, the दाखिल खारिज, that wasn't executed by him. Who has executed it was a previous officer. When this document was executed, he was not present in the school.
खारिज में लेकिन स्कूल के रिकॉर्ड से दिया है उन्होंने कि अपने घर से निकाल कर दिया है?
नहीं, वो तो स्कूल के रिकॉर्ड से दिया.
तो फिर पढ़े, आगे पढ़े, क्या है उनकी एविडेंस?
His evidence, he is PW 6 page 21.
Page 21, yes. Let us read that.
Yes.
जी.
He says, मैं दिनांक 28/10/2021 को शासकीय प्राथमिक शाला बबरिया जिला सिवनी में प्रभारी प्रधान पाठक के पद पर पदस्थ होकर कार्यरत थी. उक्त दिनांक को थाना कोतवाली सिवनी से पुलिस अधिकारी शासकीय प्राथमिक शाला बाबरिया आई थी. पुलिस अधिकारी द्वारा पीड़िता की दाखिल खारिज पंजी एवं जन्म तिथि मूल दिखाने के लिए बोला गया. मेरे द्वारा पुलिस अधिकारी को पीड़िता का मूल दाखिल खारिज पंजी एवं जन्म तिथि पंजी दिखाया गया. पुलिस ने मुझसे पीड़िता की दाखिल खारिज पंजी प्रदर्श पी 16 एवं जन्म तिथि पंजी प्रदर्श पी 17 मूल की सत्यापित कर दिए जाना बोलने पर मेरे द्वारा दाखिल खारिज पंजी की जन्म तिथि पंजी की सत्य प्रतिलिपि दिया गया था. पुलिस थाना कोतवाली को पुलिस ने सत्यापित प्रति दाखिल खारिज रजिस्टर की सत्य प्रतिलिपि जब्त कर जब्ती पंचनामा प्रदर्श पी 18 तैयार किया गया था. जब्ती पंचनामा प्रदर्श पी 18 के अस्य भाग पर मेरे हस्ताक्षर एवं स्कूल की सील मुद्रा लगी हुई है. मैं न्यायालय के आदेश पर मूल दाखिल खारिज पंजी एवं जन्म तिथि पंजी लेकर आई हूँ. दाखिल खारिज मूल प्रदर्श पी 16 है एवं जन्म पंजी मूल प्रदर्श पी 17 है, जिसकी सत्या
जन्म तिथि पैरा 4 में जन्म तिथि 22/8/2004 लेके
जी.
ठीक है, तो वो अभी 22/8 कल जो है वो 18 साल की हुई है प्रोसिक्यूट्रिक्स.
Because that is not the gospel truth. And unfortunately, my only humble submission is, we have a case. We are under for section 439 right now. We are for prima facie considerations. Now, under the circumstances, my lords, whatever is the gravity of the offense goes to one side. The current situation is that the girl and the boy both have consummated the marriage, so to say. There is a legitimate child which has been born out of that marriage, and they have resided, cohabitated, in fact, as husband and wife for a year and a half. After that, they come back into the village, and due to a previously made missing person report, they were duty bound to go before the police station, and once they did that, the police acted.
161 में prosecutrix ने क्या बोला? If you were so intimately related to each other,
yes.
161 में क्या बोला?
Well, the police is not so very nice in our state. They will record the statement as the prosecutrix says. They have to make a case.
True for all of us. None of us are so nice.
But Malad, that is where we expect judicial intervention, my lord.
हाँ ठीक है ना.
Because now the court statements are there. May I just read out a court statement?
तो पढ़ेंगे
जी. 161 देख ले.
हम तो 161 पढ़ना ही नहीं चाह रहे.
जी.
आपने ये कहानी डेवलप करी
जी
कि प्रोसिक्यूट्रिक्स और एक्यूज्ड
जी
1 साल 1.5 साल तक साथ में रहे
जी.
उसके बाद में जब गांव लौट के आए
जी.
तो क्योंकि मिसिंग पर्सन रिपोर्ट थी, इसके कारण से जो है एफआईआर दर्ज हो गई 376 और इसकी. तो 376 की एफआईआर 363 366 का मुकदमा होगा अर्लियर. ठीक है ना. उसके बाद में 376 जब ही जुड़ेगा ना जब प्रोसिक्यूट्रिक्स बयान देगी कि मेरे साथ कुछ गलत हुआ है.
नहीं, वो बोल रही है मेरे साथ इंटरकोर्स हुआ है. माय द ओनली डिस्टिंक्शन व्हिच आई एम मेकिंग इज व्हाइल द पुलिस आई एम लेट अस एक्सटेंड
just this statement is sufficient for me.
My lord.
She admits that she was subjected to intercourse.
Yes.
Right. Now the issue is that on the set day,
whether she was minor or not.
Whether she was a minor or major,
right.
that is the only
dispute. Yes.
Shadi.
Now for those circumstances, what I say is there are a few pieces of evidence. Now the law in this regard, Millers, is that the prosecution relies upon a document which we call the scholar register, Dakhil Kharij Panji. Now this is a document which we know or we recognize in law within section 35 of the Indian Evidence Act. Section 35 of the Indian Evidence Act goes to say that any document which is a public record maintained by a public officer is an admissible piece of evidence. It does not waive proof. Now, if we are to make, just for the sake of argument, if I was to make a comparison between section 35 of the Indian Evidence Act and section 293 of the CRPC, section 293 of the CRPC waives proof. under which the DNA report and FSL reports are received. The officer concerned doesn't need to come down and prove his signature on those documents. They are waived. But Section 35 does not contemplate such a waiver of proof. Section 35
क्या कहता है, पढ़ें जरा.
I'll just read it out. Gentlemen,
चलिए किताब दीजिए साहब को, ये लीजिए.
I'll just read it out for my
बड़े वकील हो गए हैं.
नहीं sir, not at all sir. I just have some good friends at the bar who help me out in times of need.
बिगर किताब के आना ही अपने आप में निशानी है.
नहीं sir. Extremely sorry for that sir. I'll just read out Section 35 for my lord. Relevancy of entry in public record or an electronic record made in performance of duty. An entry in any public or other official book, register or record of an electronic record stating a fact in issue or relevant fact and made by a public servant in the discharge of his official duty or by any other person in performance of a duty specially enjoined by the law of the country in which such book, register or record or electronic record is kept is itself a relevant fact. It only discloses this to be a relevant fact.
Yes.
It does not in any manner waive proof. Now the scholar register was brought on record by the police. If we consider the scholar register in light of the allegations earlier, the police was duty bound to register offences under 363, 376 because they at that point in time believed that the scholar register is entered on good authority.
Yes.
And since the girl, even out of her own consent, presumably went along with the boy and had intercourse, that would still amount to statutory rape.
Can there be a consent of a minor?
No, but that is what the police was duty bound to believe at that time because the scholar register existed. It wasn't proved nor was it disproved at that point in time.
Right.
But today the circumstance varies, my lords. What my humble submission is, the scholar register is a document which is created at the insistence of the person first taking the prosecutrix to the school and getting her admitted. That most naturally is the legal guardian, which is the parent of the prosecutor. Now, if my lords will just see the evidence of the prosecutrix herself and both her parents. The prosecutrix, I'm inviting my lords' attention. Prosecutrix is PW1, my lords.
Yes.
I will only read out her chief. पैराग्राफ नंबर 1 इट सेज, मैं हाजिर अदालत अभियुक्त बसंत को जानती हूं। घटना वर्ष 2020 की है। घटना के समय मैं कक्षा 9वीं पढ़ती थी। मैं घटना के समय 19 साल की थी। बसंत मेरे रिश्तेदार लगता है और उससे मेरी 1 वर्ष से जान पहचान थी। घटना दिनांक 24/7/20 को मैं बिना बताए अपनी मर्जी से बसंत के साथ चली गई थी और उसके साथ 1 साल तक रही। हम दोनों पति पत्नी की तरह रहते थे और दिनांक 11/9/2021 को मैं अपनी मां के घर वापस आ गई और मेरे साथ में मेरा बेटा भी था। मेरे मिलने के संबंध में पुलिस ने मेरे समक्ष कोई पंचनामा तैयार नहीं किया, किंतु दस्तयाबी पंचनामा प्रदर्श P1 के अ भाग पर मेरे हस्ताक्षर हैं। मौके पर पटवारी ने मेरे समक्ष कोई पंचनामा व नजरी नक्शा तैयार नहीं किया था, किंतु पंचनामा प्रदर्श P2 के अ भाग एवं नजरी नक्शा प्रदर्श P3 के अ भाग पर मेरे हस्ताक्षर हैं। पुलिस ने मेरा मुलायजा कराने के संबंध में मुझे कोई सहमति पत्र तैयार नहीं किया था, किंतु सहमति पत्र प्रदर्श P4 के अ भाग पर मेरे हस्ताक्षर हैं। पुलिस ने मुझसे पूछताछ कर मेरे बयान नहीं लिए थे। She is then declared hostile. Her entire previous statement is confronted to her in the form of leading questions. Let us just see what she responds to each statement made.
We are only concerned with the date of age of
my lords. After that, my lords will come down. My lords will come down to page 14. 1-4.
जी 1.
This is the evidence of her mother.
नहीं, इसमें प्रोसिक्यूट्रिक्स तो बता दीजिए उसने अपनी आयु के संबंध में।
वो बोलती है, ओपनिंग लाइन में बोलती है, मेरी उम्र 19 साल थी। घटना के समय मेरी उम्र 19 साल थी। सेकंड लाइन फ्रॉम द टॉप, माय लॉर्ड। मैं घटना के समय 19 साल की थी जी। She says that. And apart from that, मतलब she hasn't been confronted with her age. और बाद में जो उनको उनकी एज बताई गई है, she denies. जी। जो लीडिंग क्वेश्चंस में आया है।
पैरा 4 पढ़िएगा पेज 12 पर।
ये कहना
अच्छी एडवोकेसी ये भी होती है कि पूरी बात बताई जाए।
जी।
पैरा 4 में पढ़िएगा तीसरी लाइन। ये कहना सही है कि स्कूल में मेरी जन्म तिथि 22/8/2004 है।
We don't dispute that, मतलब स्कूल में तो उसकी जन्म तिथि वो है, but what is the probative value of that date? We cannot take that date to be the be all and end all of the case.
जी।
Now the school, now when
ये कहती है कि मेरी वास्तविक जन्म तिथि 22/8 है, तो इसका कोई प्रमाण पत्र है? उसकी भी तो कोई वैल्यू होगी ना, और she has to be believed. Whatever she says is believed as a gospel truth.
Let me just rephrase my argument. We are contesting the allegations which the prosecution has drawn against me. The prosecution comes forward with a date.
Your case, what I have understood is,
my lords,
that prosecutrix was major.
Yes.
She admits that there was a consensual physical relationship between the prosecutrix and the accused, that is your client.
Yes.
The child was born out of that relationship.
Yes.
When they came back to the village, since there was a case of missing person registered on the statements of the prosecutrix, police added section 376, blah blah.
Yes, absolutely.
This is what I have understood.
That is my submission.
Now, what my concern to do justice is that whether on the date of the elopement, prosecutrix was major or minor.
Yes.
If she was major, then yes, case will move in a different direction.
Yes.
If she was a minor, then it will have its own
Yes.
consequences.
That